Okay, good afternoon, everybody. Welcome back to the second day of our training for newly elected members of council and existing members of council of your two cities. My name again is Bill Monahan. Pleasure to be here on behalf of the Mid-Willamette Valley Council of Governments. So the other day, we went through quite a number of programs. Sorry, I had to find the clicker. I forgot that I didn't have that. We went through quite a number of foundation elements. We talked about the formation of governments. We talked about the charter, talked about public meetings law, ethics, public records law. All of those components are going to come into the presentation today in some way, because each and every one of them has an impact and a place in the land use process. The materials we went over the other day, I know we went through them in a really hurried manner because there are so many elements of governance in the state of Oregon. And of course, we didn't even talk about public budgeting. We didn't talk about systems development charges. We didn't talk about infrastructure. But some of those elements do come into play in land use, so we'll touch on them to some extent. But what I wanted to emphasize from the other day is that those documents I referred to, the charter, your own comprehensive plan, your rules and procedures, and other materials that are available to you locally, as well as the Oregon revised statutes that apply to these elements of governance, are all important for you to have access to and knowledge that they are there to be reviewed and to be resources to you. One thing that I refer to on a regular basis when I have questions asked of me about public meetings law and public records law and executive sessions is the Attorney General's model. Actually, I have a copy. Oh, wait. This is the Attorney General's Public Records and Meeting Manual. And while I have a hard copy, it's available online from the Attorney General's office. It's really valuable. I don't go a day without referring to it for questions about public records, public meetings law. So I recommend that highly to you, as well as the other elements I talked about, such as the Public Officials Guide from the Ethics Commission. But today we're going to talk about land use. And the Oregon land use system is a very unique system that is one of, I believe, only 3 states in the country where we require comprehensive plans for every communities. I believe Hawaii and Vermont followed Oregon back in the late 70s. And I'm not sure that any other states have followed since then to create a requirement that every city and every county have its own comprehensive plan and land use regulations. So we're very fortunate in Oregon that our system is very mature now. It's been around since Senate Bill 100 in 1976. So that's what, 44 years we've been in a process of developing a land use system that is really second to none in the United States. It's one that is built on the principle of protecting land, protecting our forest land, protecting our agricultural land, and making sure that cities as they develop are done so in a way that is systematic, that meets the needs of the community, that meet the needs of the long-term visions for the communities, and take into account the financial issues that are connected to urban development. And that is the need for infrastructure. So the state of Oregon requires that each city develop a comprehensive plan that not only talks about where there's going to be residential development, commercial, industrial, city parks, et cetera, but also what are the infrastructure needs so that as development takes place, it's in a way that is efficient for the long-term needs of the community. So that's why we have transportation plans, we have sewer plans, water plans that are anticipating what the future growth of the community is going to be so that we have an efficient delivery of services. And we also have the requirement of urban growth boundaries, where we make sure that development that is of an urban nature takes place within the urban growth area so that we're not extending highways and major collectors out to remote properties that are out in a rural area with expectation that that's the only property that's going to be served by this expensive piece of infrastructure, whether it's a road or a water line or a sewer line. So that's all blended into the intent of the Oregon land use system, to preserve forest land, agricultural land, and also accommodate development. So we're going to talk about that today. I also want to make reference to some documentation just in case I forget to. I talked the other day about conflicts of interest and some other topics. Today, we're going to talk about the Oregon land use system. We're going to talk about some things like, again, conflict of interest. We're going to talk about bias. We're going to talk about types of land use applications, how to conduct a successful public meeting. And in each of those categories, there's a paper that's been written by Jim Jacks, who's a planner with the COG. And I find them to be extremely helpful. I refer to them each time I do training, because those materials, although they're directed primarily to planning commissioners, of course, the same concepts apply for making information available to members of the city council. So I highly recommend those documents, which are updated as of 2019. I gave a copy to Karen that is in an electronic form, and she can either provide you, I think there's 7 different short papers. She can provide them all to you, or just the ones that you're interested in. So I started out by talking about the land use system. I'm sorry I'm stuck on the slide. The reason I'm stuck on this slide is because one thing I don't put into this presentation on a regular basis is the discussion of the Oregon land use system. So I'll just give a really brief overview. As I said, it was established by Senate Bill 100. It established that there are 19 goals that apply statewide to every city that they're applicable to. And I say every city they're applicable to because there are some that relate to coastal development. So I think there's really 14 or 15 that every city must address. But those goals include such things as citizen involvement, housing, urbanization, transportation, public facilities, forest, agriculture, etc. One of the things that, as I reflect on the system, and by the way, I've been working in the Oregon system since 1982, and it was quite an eye-opener for me when I came out to the Oregon system. I wanted to be involved in the Oregon system when I moved here from Massachusetts. But what's significant is how different our system is to those of other parts of the country. And you'll recognize that when you hold your public meetings and you have people come into your council chambers and they take part in a land use hearing and they expect that the meaning of a conditional use or a variance or something else is the same as it was in the community that they lived in another state. And they're going to find out that Oregon is different. And why Oregon is different is because when each community developed its own comprehensive plan, it also was required to develop its own development ordinances, its own zoning code. We used to just use the term zoning code, but it's expanded to typically being called a development code because there are so many other things in it besides zoning. There's things such as subdivisions, there's standards for tree cutting, there are a number of different things. But the definitions of those implementation tools is local. It's whatever you have defined them to be. And when we talked the other day about 2 types of process, legislative or quasi-judicial, the legislative process, when the city establishes its laws, it goes through a very elaborate process to establish the laws that apply to land development. So the system we have is there's a comprehensive plan that's required, and there are implementing ordinances, zoning, development codes that are necessary to carry out the comprehensive plan. And in both cases, the city has the authority to develop its own plan and its development code. When it develops the plan and the development code, however, we have to do that in a way that is consistent with the statewide land use goals. And we have to submit our plan and our development tools to the state of Oregon to be reviewed to make sure they're compliant with Senate Bill 100 and the administrative rules and changes that have occurred since that time. So let's talk about a couple agencies that you should be aware of, agencies and boards. The Oregon land use system is administered by the Department of Land Conservation and Development, and they are overseen by the Land Conservation Development Commission. So the commission is a board of commissioners appointed by the governor, who then have a staff. The staff that is responsible for reviewing the activities of all cities and counties as they relate to land development. So back in the late 70s, early 80s, as every community was required to develop its comprehensive plan and implementing tools, they went through a localized process within their cities to convert the goals into a plan that showed compliance with all of those goals, and then develop these implementing tools for how we're going to achieve the objectives of the plan. And the plans would talk about how the city was going to grow, where it was going to grow, what its expectations were in terms of economic development, infrastructure, all those various items. Then the development tools were prepared. The zoning code that a city may have had at the time was then tweaked to make sure that it was structured to achieve what the plan said. So a couple of things happened after cities prepared their comprehensive plans. First of all, they had to submit those comprehensive plans to the staff at DLCD for the purpose of it being acknowledged. What acknowledgement meant was approved that it complied with all of the planning goals. There was a secondary function, and that was that a city's or county's plan had to be coordinated with the neighboring communities, the neighboring cities as well as the county. For instance, you don't want to have a designated road that's going to be a local road that only has 2 lanes go into the next community where they've designated the road coming into your community to be a major collector with 4 lanes. So there was coordination that was necessary. There's also coordination that was taking place for where land development was going to be. If one city wanted to have single-family residential at the edge of the community, but it abutted another community that had industrial designated for its land, that wasn't going to be workable. So there needed to be coordination. So DLCD would look for both the adherence to the goals as well as compliance with coordination. They would do the acknowledgement. The other thing that was important was that there be a process for change, because obviously back in the 1970s, 1980s, we all couldn't anticipate what our future communities were going to look like in the year 2020. So there needed to be a process for regular updates and renewal. So there was called a post-acknowledgement process, where after your community's plan and development code were approved, you were given a certificate saying you're in compliance. Then there was a requirement that periodically you had to go back and look at that through what was called periodic review. And it used to be strict. It's not strict anymore. And the reason it's not strict is because the state hasn't really had the ability over the long term to be able to provide staffing to be able to go through that process. But it's still encouraged that communities regularly update their comprehensive plans and their development standards. Initially, when all those development standards were created, because cities were working with the planning staff they had, or maybe they didn't have any planning staff and they brought on their first planning staff, everyone was at a difficult place trying to decide what was actually going to be acceptable by the state, because the state didn't accept every plan that came to it. When I came out, I worked in a city that had gone through the process twice and been rejected twice. My job was to get them through the process, which we were able to do a year later. So obviously, it was difficult to come up with a plan that was compliant. So what a lot of cities did was they borrowed the work of another city. Planners back in the day used to be very good at borrowing. And borrowing meant sometimes wholesale taking of an entire section of someone else's development code or comprehensive plan and just changing the words to protect the innocent so that now it applied to your community. That might have worked to get through the process, but it doesn't work long-term. And that's why there's a need to constantly revise your plans. So I would say at this point in time, most communities have gone through enough changes that they've gotten rid of language that they really didn't understand that really applied to a city 20 miles away, for instance. It's also important to make sure that plans and codes are up to date with the legal issues that have developed. There might be case law or change of statute that apply that cause the need for a city to change its codes and its comprehensive plan. Very important principle. The comprehensive plan is at the top. The comprehensive plan is the law of the city. The comprehensive plan, what comes with the comprehensive plan is a comprehensive plan map. The map will show what the city's expectations are for where its residential, its commercial, industrial land is going to be. Then there is usually a separate map that is a zoning map, because typically within those land use designations of residential, commercial, et cetera, there'll usually be subsets. For instance, in residential, there'll be single family, there'll be multifamily, and there might be 3 or 4 different types of single family and 2 or 3 types of multifamily. So the zoning code will get down to more definition of the specifics of what's allowed in areas within the community. Then there's the implementing language that tells us the process or tells us the definitions of what can take place in any of those zones when someone wants to make use of their properties. What's important to keep in mind is if there's conflict between the zoning ordinance and the comprehensive plan, the comprehensive plan rules. And this was established in the Baker versus City of Milwaukee case back in the 1980s. When the City of Milwaukee had a comprehensive plan, it had a zoning ordinance, and when it came to a land application, the city decided that it liked the language in the zoning code a little bit better, and it applied that to a land use application. A lady by the name of Baker, who actually still lives in the City of Milwaukee, she challenged that decision, and the Oregon Supreme Court made a decision that the comprehensive plan is the primary document. That's the one that takes precedent over the others. So what's that tell us? We can't have conflicts. We have to make sure that the zoning code and the comprehensive plan and the comprehensive plan map are all in concert. When the earliest plans were developed back in the 80s, there were many inconsistencies because there might have been a planner who was working on the land use section. Another person might have been working on the housing section. Another person might have been working on the transportation section. Sometimes they had engineers working on the transportation section, and their use of language may not have been consistent and their understanding of the terms consistent. It's important that as we go through the process today, that the terminology and the process that a city has be understood by the city council, by the planning commission, and by the practitioners within the city, so that there is consistency in the application of those tools. So that's my long introduction to the background of the Oregon land use system, which again, I still think it's a great system. Of course, I'm a lawyer. Lawyers like process, and many other people don't like process. But the process that you have in your cities is unique to you. You, over the last 40 years, have developed a system that works for you. I've looked at to some extent at your codes just to see what do you have in terms of your types of land use approvals. And you have very similar, but not not exactly similar language in your administrative section where it talks about what decisions are approved by the planning director, what decisions of planning commission, and what are the city council. But there's a lot of similarities. But if you delve into the code a little bit further, I think you'll find that a lot of the definitions and a lot of the process is different. Every community in Oregon is unique. So let's get started. We'll talk about the land use hearing fundamentals. So what I like to cover in a presentation such as this is I like to go through enough information so that a member of the city council or planning commission can get a feel for what their role is going to be and what the expectations are for them as they carry out their functions. And again, some of this is going to be repetitious, but with more detail of what we talked about the other day. So I'm going to talk about the tools that I think everyone needs to be familiar with. I'm going to talk about the roles and hearings and best practices. And the ultimate best practice is transparency. This entire system has been built around the expectation that our process is going to be transparent to the public. It's going to take place with the opportunity for our citizens to be involved. I mentioned the 19 goals, the statewide planning goals. Goal number 1 is citizen involvement. And I believe citizen involvement is goal number 1 for a particular reason. I think the legislature intended to send the message that our plans, our process, our decisions are to be ones that involve and are in the best interests of the citizens of the community making the decision. So everything within what we're going to talk about today is within the context that there's an expectation that the system is built so that citizens can be involved. But I want to also emphasize another thing. The title of the department and the commission that regulate land use in the state of Oregon. It's the Department of Land Conservation and Development. It's the LCDC, Land Conservation Development Commission. It's a balance between conservation and development. So there's an expectation that yes, we're going to preserve our farmlands and our agriculture, but we're also going to recognize that development is important to provide for the needs of our citizens as communities grow and as they develop. So there's an expectation in our system that we're looking out for the needs of conserving our natural resources, making sure that any development that takes place does not harm the environment, but also that development is allowed and done in a regulated and proper way. So we're going to be touching on a number of those topics today. Here's some of the land use tools that communities have. As I talked about, the comprehensive plan, the development code. The development code implements the comprehensive plan. The development code in some communities is just a series of ordinances. They may not have consolidated them all into one. It makes it a little bit difficult to operate, but it does work. And there are also studies. Studies might be, for instance, the city's long-term need for economic development. So an economic development study. It might be an environmental study. It might be a transportation systems plan. All of those are part of your overall land use system. Then the basic tool, staff reports. So we'll talk about that extensively. The Oregon revised statutes are a number of statutes that apply to land use, transportation, infrastructure. Then there's your own local rules and procedures and scripts I talked about the other day. And then other tools that are available to you is you can provide for training and work sessions. And then most important thing of any land use tools is the coordination of the teamwork of your council, your planning commission, your staff, and your other resources. Here's the roles. Council plays roles, the council's role in land use is either in a legislative way or on a quasi-judicial. I'm focusing this primarily on quasi-judicial. But as we said the other day, your legislative function is when you create or modify the comprehensive plan and also when you create or modify the ordinances and the studies that are used to carry out the comprehensive plan. When you do a modification to your comprehensive plan, for instance, I noticed that both of your communities are just under 10,000 population today. House Bill 2001 that was passed by the legislature in 2019 is to address the middle housing need that exists within the state. There's a need to make modification to our zoning ordinances. I remember I said the other day that the government, state government rather, doesn't get into dictating what takes place in a local community unless they preempt something. Well, in 2019, House Bill 2001 basically preempted your opportunity not to allow for the type of housing that the state has identified we need. So what House Bill 2001 does, it is setting limits and say, if you're within a community that has over 10,000 people, you have a certain standard. If you have over 25,000, you have another standard. 2 days ago, while we were in this training session, the state of Oregon sent out its decision on the administrative rules that will apply to cities over 25,000. And it says that in single-family residential areas, the areas that allow single-family residential, there must be the requirement allowing duplexes, triplexes, fourplexes, and some other forms of housing. And cities have to come into compliance, I believe, by July 1 of 2022. Well, regulations went into effect for cities of over 10,000, or rather they're going into effect next year, but the rules were adopted earlier this year that says that in those single family residential areas, a duplex needs to be allowed on every lot. I believe that's what it says for cities of over 10,000. You're not there yet, but you're going to be there. So obviously your planners are thinking about that, and you're already thinking about that as to how you're going to go through that process to revise your standards that right now don't allow for a duplex on a single family lot. When you do that, you'll have to provide notice in advance, I think 35 days, to the Department of Land Conservation and Development saying, these are the ordinances, excuse me, these are the ordinances, these are the maps, et cetera, that we're looking at revising to be in compliance with House Bill 2001. Then you go through your process, and then after you've gone through your process, you then need to send a copy of the final document that you adopt within a certain period of time after adoption. And the state's going to look at those to make sure you're in compliance. So you have a continuing role as legislative decision makers, and there's a process that you need to stay in coordination with the state. But primarily, we're going to be talking about your role today as a quasi-judicial decision maker. And I noticed in both of your codes that there are some decisions, I think they're type 3 decisions, might be type 4, type 3 decisions. Yeah, type 3 decisions, you are the primary decision maker on. Now, your codes will define type 1, type 2, type 3. Type 1 are decisions that are made by your planning director. There are clear and objective standards. It says, if such and such is proposed and it meets the following, that type of application can be approved by the planning director. And there's very little process. There'll be notification to adjoining property owners, but there won't be a public hearing. And if a property owner receives that notice and looks at it and objects to it, they can file an appeal. Those types of applications are typically things like land partitions. They might be a minor lot line adjustment. And by the way, a partition is any division of land, a lot of land, that creates up to 3 lots, not 4. If you get into creation of 4 lots within a calendar year, it's called a subdivision. And with the subdivision, there are other standards that come into play. But if somebody wants to go through a land partition, they can go through that process and have it approved by the planning director. The second level, titled type 2, typically is a subdivision. It might be a site design review. It might be a variance. Might be a conditional use. Now, these are all terms that those of you who have served on the Planning Commission or on the council in the past obviously are familiar with, but some of you may not have had the joy of finding out what all of these different terms mean. Your development code is going to tell you what they mean. And again, I've got a paper that Jim Jacks prepared that does a really good job of distinguishing the difference, but I'll give you a quick overview of a couple. Subdivision is when a piece of property is being developed, or rather it's being divided up into more than 4 lots, and it's going to lay out a plan for what the future development of that lot is going to be. It might be a residential development, it might be a commercial development. It might show the size of the lots, where the streets are going to be, where the infrastructure, the water lines, sewer lines, et cetera, are all going to be. It might show where there's going to be a drainage facility to take care of the drainage on site before it goes into the city system. Anyway, the subdivision, if someone applies for a subdivision, there are strict standards they have to apply for. They develop a preliminary plat of the property showing what's going to be there, accompanied by a lot of detail. And the Planning Commission typically will review that and find if all the standards are met, it's approved. And by the way, that's another overriding principle that you all should know. When the city creates its zoning code and the criteria that are defined that need to be met in order for a property owner to develop their property for a particular use, if the property owner adheres to all of those criteria, the system is set up so they win, they get an approval. The city needs to provide that approval. Now, there's some discretion on how some of those criteria are met, and that's usually reviewed at the Planning Commission or the City Council level. So there are subdivisions, there are variances. Variances are when someone wants to use their property in a way that's a little bit different than the code specifically allows. Now, the state of Oregon does not allow variances to allow a residential piece of land to be used for a commercial purpose. You can't get a use variance. That's what that is. You can't get a change of use to allow something to occur that isn't legally allowed. If somebody wants to change a piece of land from residential to commercial, they have to petition through the city council to obtain a comprehensive plan change and a zoning change, because we need to change the map so the community can see which properties are going to allow that type of development. But you can go for a variance where all you want to do, for instance, is site a building, and perhaps the building would be 9 feet from the property line on one side, when the zoning code says you have to have a minimum of 10 feet of a variance. You might have or rather 10 feet as your setback. You might have a process that allows you to process minor changes through a variance process. Actually, you will have that process. What you might have is that might be an administrative decision if it's very slight, but it might be a planning commission hearing if it is a major change. So there's a number of different types of land use actions that are processes of type 2. The type 2 decisions that the Planning Commission reviews, they'll go through the process that we're going to talk about today. And if someone wants to appeal a type 2 decision, they'll appeal it to the City Council. Now, I also should mention when there's a change to the comprehensive plan of the development code, that's usually a 2-step process. That the first level of review is the Planning Commission. They'll make a recommendation for a change, and that will go to the City Council. The council will go through a same process, but the council makes the decision. The Planning Commission is typically allocated responsibility for making type 2 decisions that are appealable to the City Council, and then there are some decisions that are reserved by the City Council that only it holds a hearing on those issues. I think when I looked at your codes, annexation was one of these topics that your cities differed. I think in one community, the planning commission looked at annexation questions and then they made a recommendation to the council. I think in the other community, all annexation questions went directly to the council. Again, that's your right, that's your choice. Okay, so going back to roles. The mayor presides over the meetings and is responsible for maintaining order, as we said, under the Oregon Public Meetings Law, and follows the process and guides the council through to decision making. And in both of your communities, the mayor does not vote on any matters under, according to the charter. So I assume that means also the mayor doesn't vote in land use matters, which is a little bit challenging because the mayor is going to be just as involved, I assume, as other members of the council, asking questions and wanting to understand what the meaning and the intent of developments are. The planning staff, they're your experts. They're the initial point of contact for applicants. So an applicant, by the way, comes to the city, says, I want to know what I can do to develop my property. And we point them to the same information that we've been referring to, the comprehensive plan, zoning map, implementation measures. But they'll typically ask for a pre-application conference. They want to come in and they want to find out what the staff says they have to do to develop their property. And they may have, and they usually do, have some concept drawings to say, this is what I'm really thinking about doing. They may or may not be totally serious when they first come in as to what their ultimate intent is. But they'll show enough information about what their plan is so that the planning staff can tell them, these are the criteria that would apply. This is where they may even tell the applicant, the future applicant, that these are some other decisions that have been made. You might want to look at those and see how those fared at the Planning Commission and City Council and what the conditions of approval are. Now, I've just introduced a new concept, conditions of approval. The ordinances will say, or the ordinances and the regulations will say what someone needs to do to comply with the requirements. But sometimes an applicant will make an application and it's really questionable whether or not they should get an approval. In their minds, they've met all the criteria. But the staff may have said, well, we're not really sure about that, and you need to show more information. Well, when the information comes forward and is looked at by the Planning Commission, then the City Council, the decision maker has to decide, has the applicant met all of the criteria so that they can get their approval? It may be crystal clear, or it may be questionable in some cases. In some cases, the decision maker has to say, we can approve this with the following conditions of approval. The developer must submit, for instance, a revised transportation plan showing the following, and they might be a lot of detail, or a revised access from the road into the property that meets the standards in a more clear way than the proposal that the applicant has submitted. So those are conditions of approval. When a land use application is before the Planning Commission, then the City Council, these are the options. It can be approved, it can be denied, or it can be approved with conditions. And when those conditions are stated, they need to be clear enough that the applicant can understand them, the community can have an expectation of what's going to be done to make this compliant, and the staff needs to know what they're going to be reviewing to make sure it's in compliance. So the staff are the experts on handling, getting through that initial application process and providing information. Once the applicant decides they are ready to go forward, they'll submit an application under the requirements of your local code. Your code will say what is needed to make application. And it's a lot of detail as well as a filing fee. Once the application is submitted, the staff has 30 days to review it for completeness, to make sure that there's all the information that's required for them to make a decision or for the Planning Commission to. Once the so if it's not complete, the staff will send a note and say, these are the things that we need to make it complete. The applicant can decide whether to submit more information, or they may say, no, I want to stand on this application. Call it complete, we'll go with that. At some point in time, the application is going to be deemed complete. Once it's complete, then a couple of things happen. The staff starts setting into motion the process of how it's going to be reviewed. Either they're going to do it, or they're going to put it onto a planning commission agenda in future into the council if it goes on appeal. In addition, it locks in the development criteria. This is important because if a developer comes forward and says, this is how I want to use my land, and this is what your code says I can do, and if you really haven't looked at that code language for a while and kept up with how development is changing, what I mean by that is maybe you've got a provision that talks about how someone can use a piece of property for an industrial purpose. But the definition of industrial as commonly used today has evolved so that industrial isn't just making things and warehousing, it also involves some commercial activities. If you haven't looked at your code in a while and it says someone can do this under the following conditions, and this person applies and meets those conditions, you need to review the application on those standards. You can't say, oh, stop. We're wrong. Now that we've looked at that for the first time, we've realized that language doesn't work. That type of development is going to be a major problem. If they've made application, their application is deemed complete, they lock in those standards. You have to process it under those standards, make a decision under those standards. If you want to change your code and your comprehensive plan later on, you can do that, but you can't apply it retroactively. You can only apply it for future applications that have not been deemed complete. So here's what the staff does. They'll provide a staff report for you that explains their expert analysis of how the application meets the criteria. They'll make a recommendation. They may recommend denial. They may recommend approval. They may recommend approval with conditions. There are very few applications that make it through to a land use hearing that makes it all the way up to the city council that the application has been recommended with denial by the planning staff, but it does happen. They then, after the fact, will assist the planning commission and then the city council with decisions and with findings. We'll go through that in detail. And they'll process any appeals, and appeals have a unique characteristic to them. And there'll be a resource during the public hearing to respond to questions. And by the way, they're also a resource, of course, to the citizens. Citizens are going to get notice that there's been a land use application. They're going to have concerns. They want to have the same understanding of how the code applies and what needs to be done to get approval. The planning staff will assist during the process to prepare modified conditions, and they'll prepare findings that we'll talk about later. And then you may or may not have your city attorney involved at hearings, but your city attorney is always in the background to assist the staff and the council and planning commission with questions of the meaning of terms, the meaning of process, and they can provide assistance at the tail end of the decision-making when we're preparing conditions and findings. So what do city council members need and expect? From the planning staff, we always want to see well-prepared and understandable staff reports. Usually there'll be one recommendation. It'll say approve with the following conditions or deny because the following criteria have not been met. There may be alternatives. The idea, though, is that there's enough information for you as decision makers to move forward and to prepare yourselves before coming to a hearing. They'll identify what the criteria are and the options. The other thing you need from them is the ability to explain the code language to you in the public hearing and to the citizens. They have a responsibility once they get an application to also take that application and send it out to a number of other people for assistance. They may send it to the fire marshal. They may send it to the city engineer. They may send it to the fire district. They may send it to ODOT. There may be a number of agencies that have a need to be involved. Typically, they'll send a residential application to the school district. And they'll say to the school district, do you have capacity for this proposed residential development that could take place in this part of the community? They get the information, and it's their responsibility to put that into the package so that you have it all in front of you. That's the way that that information is obtained. We don't want members of the City Council or Planning Commission going out and asking those entities on their own, oh, by the way, what do you think of this application? That's an ex parte contact. That's not good. So we want the staff to do that. They assemble all that, and in fact, some of those people may even be participants at your hearing, because it's so important to them that their message be understood by the council. So they'll try to answer all your questions fully and accurately. Sometimes they'll have to say, we don't have all the information today and we'll have to get more information. That may result in a continuance of a hearing. They'll try to provide you with complete and objective answers and guide you when needed and appropriate without trying to without trying to direct you towards making a decision. That's not their job. That's not the city attorney's job. Our jobs are to provide you with all the information so you as an unbiased decision maker can make your decision. And of course, it's always important to show respect to the commission and the public and the city council. Sorry, I missed that when I changed this from being a commission PowerPoint to city council. Obviously, the council needs to be shown respect too, because we want to make sure that the community sees us make these decisions in a way that they can believe in and know that it was done in an appropriate way. And they'll also identify any needs for follow-ups. They may find during the course of a process or a city council hearing that, oh, we need to change the code because it didn't really work the way we intended, and there's a way for us to improve it. Or they may decide there's a need for some training for the city council because they've recognized that they haven't done a good job of explaining how things work, and there's some misconceptions and misunderstandings. They may also find that there's a need for the city council and the planning commission to get together. I emphasize this because in some communities, the planning commission and the city council will meet at least annually to talk about what the goals of the community are. The planning commission's role not only in reviewing land use applications, they also usually have a role in the capital improvement program. They might have a role in the visioning. And as a result, we want to make sure that the planning commission and the city council are connected and have the same understanding of what the direction of the community is, and also how these implementing tools and comprehensive plans are to be interpreted. There are times that a planning commission will make a decision. They may recommend denial of an application, and it might go to the city council on appeal, and the city council finds that all the criteria met and they approve it. Well, unless there's some communication between someone on the city council to the planning commission of why there was this difference of decision, it's possible that there's going to be a continuation of a misunderstanding. And in fact, there have been situations where planning commissioners have decided, why am I here if the city council doesn't accept our recommendation? And that could have been fixed perhaps by some communication and some training. Okay, let's move ahead. What do you need from the city attorney? Obviously, accurate legal advice and assistance through the process, providing you with assistance to make sure that none of you get into a problem on conflict of interest or bias. Always a resource to the mayor in responding to issues, and if necessary, maintaining decorum, and as an expert to assist on those post-decision processes where there's a need to make some change.
Hey, Bill, this is Tom Pest,
Okay,
Mayor.
what's needed from council members? Well, obviously these two sessions are hopefully going to help you to make sure that you have a better understanding and knowledge of the plan and the code and your rules and procedures. We need you to be fully prepared for the meetings. And granted, I recognize that oftentimes you're going to get a very large packet, and land use is usually the element of a packet that takes up the majority of space. There could be an appeal that has 200 pages of documentation. Staff reports for land use actions are required to be available 7 days in advance of a hearing. But sometimes they're only available 7 days in advance of a hearing. And if your hearing is on a Monday night, and if you've got plans over the weekend to be out of town, you get it on Monday and you're busy during the week, you might have a very difficult time getting up to speed to be fully prepared to participate as one of the decision makers. So it's important, if you can, to read your packet and identify where there are areas that you need clarification. And if you do need clarification, try to get those questions to the staff as soon as you can, because as is likely to happen, a question you have is going to be one that a fellow member of council has. The staff can get you out those answers in advance of the meeting, and they'll probably add it to their staff report. Be sure when you're at the meetings, of course, to listen carefully to all who participate. A recommendation that I have, that I've given many, many times, is I've seen council members when they're at a hearing, a lot of them will have their head down because, again, there's sometimes 100 or 200 pages. It's very important when there's a member of the public speaking to try to have eye contact with that individual so they know that they're being heard. Because when people come to land use hearings, and again, it might be the first time they've come to a council meeting, we hope that they all are not coming with the expectation that they're going to get their way. We know, though, that they all do want to be heard, they want to be understood, and they want to be respected. So the way to achieve that is for the council to show that they're listening, that they're actively listening, and that they are appreciating the fact that the people are there making this effort. And one simple tool that I like is when citizens get up and they'll raise their various issues, you may not get a chance to comment to each one of those people as they come up to speak, because you might have 15 people that want to speak and they all have 3 minutes. Oh, okay. All right, let me just finish that one item. So my recommendation is, if at the time that the public hearing is over, when the city council is going into deliberation, if someone on the council can have the task of saying, before we discuss our interest, our direction, I'd like to make sure we understand. Mrs. Jones, she raised an issue about transportation. Here's what here's something we discussed about that. We heard Mr. So-and-so say such and such. People like to be acknowledged and have it known that their issues have been heard and understood. Yeah, questions? I'm in charge of questions?
I got a turn.
Oh, okay. Okay, who has a question?
I'll go ahead. I have a question. This is Christopher Lopez, City Councilor, City of Monmouth, in the middle of my first term. So this is a great review here. Specific to land use applications and the criteria. One of the criteria that I've had the most trouble kind of wrapping my head around is the criteria of being compatible with surrounding property uses. And you know, from my understanding, land use decisions are very regimented. This seems to be a you know, something that's more subjective regarding that compatibility. Could you touch on that?
Yes, Christopher, thank you very much. That definitely is a subjective criteria. In some cases, for partitions and lot line adjustments, small variances, those have to have clear and objective standards. And in fact, residential development standards now need to be governed by clear and objective standards. But there are many holdover statements in criteria that talk about compatibility. That leaves the city council in the position of exercising discretion. And my recommendation is that when you have those standards and the city council is making an interpretation, that you do your best to get as much information in front of you as to what the factual situation is, and have the city council talk about what its meaning is of compatible. Your challenge is going to be compatible to a neighborhood means what? Compatible to the entire neighborhood? Compatible to those within 50 feet of the development? Is it compatible to just that section of the neighborhood? It's a very difficult standard to address.
Thank you. As a follow-up to that, because I'm still trying to wrap my head around around exactly the amount of liberty we're given under land use law. Talking about the neighborhood and the neighboring properties. Is that only defined as the tax lots that are immediately touching it, or what do we define neighborhood as? What is the accepted range there?
That's local. That's local for you to define. There isn't a state code that defines it. There may, however, be some decisions that have been made by the Land Use Board of Appeals defining those terms that can give guidance to a local community for you to look at and see how do we adapt that to make sure that our code is compliant with state law and the decisions. So go back to the discretion that I talked about the other day. The city council, when it makes a land use decision, its decision is given quite a bit of authority if it's brought up on appeal to the Land Use Board of Appeals. But it's important that the city council make a clear record of how it interpreted its code and what its intention was. So if that compatibility standard goes back 30 years and hasn't been modified and hasn't really been better defined, as you've described, then you might run into problems on appeal. So that's always one of those criteria that I think requires some attention. And that's one of the ones that the Planning Commission and the City Council need to be totally in sync as to what their interpretation. Okay. Yes, got another question here.
What takes precedence? The government's high density program for residential to go like the duplex and triplex, or school capacities?
Okay, so this new bill, House Bill 2001, is going to create an opportunity for the middle housing. It's going to require that all local governments meet the law. The school capacity issues become one where you're asking the school district what their capacity is. Basically, you should be in coordination with the school district from the creation of the plan and as you update the plan so that the school district is getting information as to where development is going to take place so they can do their long-term planning. We know the issue is always money. And it may be that they have to go to the voters to get approval to build new facilities, or more important, usually we get money to build facilities. We don't get enough money to staff them and provide the operational costs. But the precedent, I think, is going to be House Bill 2001. And that's why they've got an implementation set off a year or 2 years, depending on the size of the community. School districts need to take note of that and start making their best efforts to prepare. Now, there is a thing that I don't include in my presentation, and that's moratorium. There can be a moratorium declared that prevents development for a period of time. In some states, moratorium allows the city to say, we don't have enough capacity for development. We're not going to take any more land use applications until we're ready. Oregon doesn't allow an open-ended situation like that. A city can create a moratorium going through a established by state law process to declare a moratorium for only 6 months. And in that 6 months, the city has to get busy and come up with a plan for how it's going to address this inconsistency. Schools can be a moratorium issue. I think they can be a moratorium issue, or no, they can't be a moratorium. And the mayor's correcting me. In Oregon, schools cannot be the moratorium issue. But the same principle applies of coordination of the school district with the city, so that decisions that the city makes, you're taking into account what's the impact going to be on the school district. But the duplexes, again, that's the preemption issue. State's taking control of that. Okay.
So Bill, this is Tom Pesper. Can you hear me?
Hi, Tom. Yes.
Yeah, I just wanted to make a quick comment on Senate Bill 2001, at least as far as independence goes. We've actually always allowed a duplex essentially on single-family lots or accessory dwelling unit. So, but we did have to make some adjustments to our code because there were some things that were also buried in that legislation that you couldn't require that the property owner live on the property and some other things. And we had some of those restrictions. So we've kind of already dealt with that. And I guess I would say I don't think in independence, unless I'm missing something, that we're going to see, you know, a flood of new residents based on that, because it's something that's really kind of been in our code for a fairly significant period of time.
Great. Thank you, Tom. That's great clarification. You're ahead of the game. You might need to take a look at the code provisions for requirements for parking. There might be some other things. I didn't intend to go too far into 2001, but when I saw you were both close to 10,000, I thought it was important to mention. But thanks for that clarification, Tom. Other things council members need to do is understand the law, and that's a lot of what we're talking about. ORS 197-763, if you take a look at that, that'll give you a roadmap to why you have the scripts that are used in land use hearings, and it shows you the requirements that the city has to handle land use. ORS 244 we talked about the other day, that's the Oregon Government Ethics Commission, and 192 is the Public Meetings and Public Records Law. What we need from the citizens? Well, of course, we need to make sure it's an open process for them so they have access to the same information that we are making available to the development community. They need to have easily understood procedures, if at all achievable. They need to have staff available to them. You'll see that on every land use notice, it will say, this is the land use application that's being applied for. This is when it's going to be going to hearing. Here's the staff person that you can contact for further information. And the staff will provide that information. It also, the public needs to have access to all the plans and codes and materials, and they need to have an unbiased decision maker. And that's what we're going to spend the bulk of the time today talking about, and that's due process. So we're going to talk mostly about quasi-judicial, but I talked a little bit already and said the difference between legislative and quasi-judicial. The difference for legislative is that's when you're adopting laws, you're modifying the comprehensive plan, and typically the Planning Commission takes the first step. They'll make a recommendation, then the City Council makes the decision. But in the quasi-judicial process, the Planning Commission or the City Council is in a different place. They're acting as a judge or a judicial body. They are applying established criteria to a set of facts to make a decision. In the legislative process, it's less restrictive. We allow council members to obtain any information that they think is important for them to be an informed person to make their decision. You can talk to anyone. You can review things on the web. You can do any search you want. And it doesn't matter when it comes to ex parte contacts. There are no ex parte contacts in legislative decision making. The notice that's described in a legislative process is different from that in a quasi-judicial, and the findings that are required are different. So let's go through that a little bit. Legislative process, you're sitting as lawmakers. The information that you use can come from many sources. It doesn't have to all be in front of each and every member of the City Council. You can have your own individual research. The findings that you make are less specific. If you're making a change to the comprehensive plan, you're going to be saying why the changes to comprehensive plans adhere to those statewide land use goals. That's the primary thing that you're going to use. But you need to make some statement as to why what you're doing is compliant. You also have to have adequate findings or accessible materials in the record. I say this with some hesitation because when you see Jim's information, I believe it says that no findings are required in a legislative decision. And that's correct. No findings are required. You can just say we've made this decision. A finding, by the way, is a statement of the connection between the criteria and the facts and how you reach the conclusion you found that the criteria were met because of these facts. You don't need those in a legislative decision as long as no one challenges it. I represented a city several years ago where they had gone through a process. This was back when we had some communities that were creating larger standards for development. They were creating standards that said a house had to be a certain size. When they did that, they didn't create any findings, and it was challenged by the home builders. When it went up on appeal, and I had to represent it at LUBA, I found that no findings were stated, but I was able to point to the record and find that there were enough statements, and I put those statements together in my brief and was able to convince LUBA that the accessible materials in the record showed that the criteria had been met. Well, why go through that legal cost when all you have to do is to create some findings? So my recommendation is always create findings in the legislative process. Quasi-judicial, that's when you're as an impartial tribunal. Articles 5 and 14 of the US Constitution require due process. Impartiality means that you treat everybody equally. The applicant, anyone who appears for and against or neutral. Allow all parties to know what you know. What that means is all parties need to know what you're going to make your decision on. That's why we don't have ex parte contacts. The ex parte contacts that you do have are not something that requires you to not participate in the process. If you have an ex parte contact, your obligation is to announce it. Yes, ma'am.
You define ex parte contact.
I am going to.
Okay.
I'll do that. I'll do it quickly here. An ex parte contact is any contact that is made to you by someone who's interested in the application outside of the hearing, meaning the other members of the decision makers and the community at large are not aware of the fact that you've had this contact where someone is either asking you a question, what's your opinion, how are you going to vote, or here's what you need to know as you make your decision. So an ex parte contact is anything that's not in the room, okay? And an ex parte contact can be someone talks to you, someone sends you an email, you read it in the newspaper, you get a contact from somebody, like a developer sends you a piece of information that says, oh, by the way, you should know this. Impartial, I'll make sure I didn't go too far, did I, Jacob? Just one? Okay, I didn't. Okay, impartiality. The information considered should be factual. Now, we know that sometimes people will state an opinion. It's your job to review all the information available to you and make a decision that's based on the best facts available. Sometimes that's challenging. The process allows information that's placed before you to be challenged by participants. That's part of due process, the opportunity for someone to rebut information. In order for a participant to challenge information, though, they need to know what has been submitted. So if somebody sends you an article that is supposed to influence you on a decision, bring that article so that it can be made part of the record, so that all the other members of council, the community at large, can all review and see that article. By the way, I see this many times. Someone will come to a hearing, they'll bring a prepared statement, maybe it's 10 pages, and they'll say, you might have a restriction of only 3 minutes for someone to speak, and they start to cover the 10 pages, and then they're restricted, they can't say anything more. I want to submit this for the record. When someone submits something for the record, they ought to be given the city recorder enough copies for everybody who's on the council, as well as the staff, as well as the applicant, as well as anybody else that wants to see it. But then once you get it, you need to read it. There have been too many times that within one of those submittals by a lawyer for a person who's opposed to something, they'll submit some challenge to a criteria on page 9 that is not addressed by the city council, and that can result in something being sent back to the city from LUBA. I only mentioned the Pisano case to show you that this, before Senate Bill 100, Oregon finally established in 1973 the fact that decisions were not, shall we say, arbitrary or at the whim of the local government or the court. In fact, in 1973, in the Pisano case, which is a Washington County case where someone wanted to change land, I think to allow for a mobile home development. A challenge was made that the city didn't have a process that really was consistent with due process. So this established for the first time that in a quasi-judicial land use decision, there needs to be the opportunity for everyone to be heard, the opportunity to present and rebut evidence, and we'll talk about how that works, an impartial tribunal, and that the decision's made on the record and the decision is supported by findings. Back in the day, decisions were made and no reason was given. If there's no reason given for a decision and there's no findings, how do you appeal it? And how does a review body, and back before Senate Bill 100, that review body was a court, how did a review body make a decision that the city did what it should have done? So I'll introduce now, and I'm going to cover it at the end if we have time. If there are appeals beyond the city council, those go to the Land Conservation Development Commission. I'm sorry, LUBA, the Land Use Board of Appeals. The Land Use Board of Appeals is unique. It is a specific to only land use court. It's made up of 3 lawyers who've been appointed by the governor, and they are land use experts. They rule on all land use issues that are appealed related to local government approvals. In other states, decisions are appealed to the circuit court. It may be a circuit court judge who does criminal work or real estate work, or it could be a tax judge. And as a result, they may not have a very good understanding and they may not have an appreciation of what you're trying to do in your community. We're very fortunate to have a specific court. And if I get a chance at the end, I'll tell you about some of the changes that have happened there and what they do. Elements of due process. Elaborating on what Fasano established, we now have to comply with what is basically an administrative hearing process. If you've had any experience working in Social Security or in some contracts, some contract appeals or collective bargaining challenges that go to an administrative judge, there's an administrative process that's pretty much the same as is defined here, due process. There's the opportunity for someone to present and rebut evidence. Every party has a right to present the evidence and rebut. In a land use hearing, usually the staff will go first, then the applicant will speak and present its application. And then the next speakers are people who are either for or against an application. When a citizen comes and speaks after the applicant, that's their opportunity to get their information to the council and to rebut what was said by the applicant or rebut what was said by the speaker before them. But we don't preserve the right that the first speaker of 20 gets the opportunity after all 20 have spoken to come back and say, I want to rebut what speaker number 2, 3 through 19 said. Otherwise, it never ends. So you have one chance to rebut. The applicant, however, always has the last word and usually reserves the right to rebut all of the information given throughout the hearing. So that's the basic element of due process. Council has the right to set time, place, and manner. So you can decide, we're only going to allow everyone to have 5 minutes to speak. And as I said the other day, if you're going to do that, make sure you follow it consistently. The council can also create the order. You can decide whether you're going to have neutrals speak before proponents and opponents. And the council has the right to hold the record open if it needs more information. To rebut evidence, you need to know what evidence is in the record and the opportunity to review it. And that's why it's important that documents be available, the application, the staff report, the codes, etc., before the hearing. The record. The record for a city council is differs in different communities. In some communities, when you have an appeal from the planning commission, in some communities, the city council's appeal is on the record, meaning it's restricted to just what the planning commission had before it. No new evidence is allowed. In some communities, they allow certain new evidence. It might be new evidence that wasn't available at that time, but it's pertinent to the application. In some communities, it's de novo. And de novo means new. We're looking at it all over again. I think yours is a little bit of a hybrid, but mostly de novo. Is that right? Both Independence and Monmouth, I looked at your language, it's pretty much the same. It says that you're going to get a report from the Planning Commission of what happened at the Planning Commission. But it doesn't say that you're restricted to just reviewing what was said at the Planning Commission. An appeal on the record is really difficult to maintain, or rather to conduct, because it's difficult to know who has the right to speak. It's difficult to know whether something was already brought up at the Planning Commission, that is in the record of the Planning Commission. So I think your process is probably more suitable to being able to be done in a way that is efficient. But the record is finally established once you conclude your actions. And the record is any documentation, anything that's been submitted to be considered. It's the minutes of the hearing. It's the tape of the video of the hearing. And it's the decision. The record's important because if at the end of the day, a decision is appealed, you have to assemble that complete record and make it available so that LUBA can review it. And that record becomes available for anybody who is an appellant or the applicant because they need to prepare for their participation at LUBA. The record is everything that's placed before the City Council during the hearing. I've said this a number of times in cities that have an on-the-record review of a Planning Commission's action. I've said, well, when you had that on-the-record review, did you bring the box in that had everything that the Planning Commission had? In many cases, it's what box? Well, it's the box that your staff created where they've been keeping the entire files, all the documents, all the exhibits. Well, no, we didn't bring that into the room. Well, then you didn't have the record in front of the council. If the council member wanted to ask, can I take a look at that? Or the public. You don't have that issue. But the record going forward to LUBA is going to be everything that came before you. When the council hears an appeal, well, I already said that. The record materials are all these different things. It can be photographs, it can be exhibits, it can be letters, it's minutes, it's anything that is in front of the decision-making body. Here's some brief procedure requirements. I mentioned ORS 197-763. If you take a look at that statute online, it'll list all of these things that you need to do in a land use process. You have to have a notice of the hearing. It'll say what the hearing is going to be. The notice is going to say when it was sent and who it's been sent to, because your local requirements are going to say for each type of activity, who gets notice. The applicants gets the notice. Citizens within X amount of feet of a property will get notice, and it may differ. In some cases, it might be 100 feet, it might be 500 feet. Well, someone needs to have an affidavit in the file to show that that notice went to everyone that is entitled to notice. If someone doesn't get notice who should have been entitled to it because of your local code, they can ask for a continuance, and you should stop the hearing until they get actual notice. They may have, well, I just introduced the term actual notice. Actual notice is, I actually do know that you're going to have a hearing. And a council member may say, well, you're here. Well, yes, but I just learned about it when my neighbor told me while he was pulling out of the driveway that there's a hearing about our property behind us. Yeah, I know about it, but I haven't had any chance to prepare. But actual notice is typically, yes, you actually received it, but did you get it on time with a sufficient notice of the hearing so that you can prepare? The staff report is outlined. What the elements of that are is stated in the statute. It'll also say that documents submitted by the applicant in support of it must be available to the public. What this means is that the applicant's materials need to be part of its submittal in advance of the hearing. If they submit something at the hearing for the very first time, say, oh, by the way, I've got a better piece of information that you should have, then there should be the opportunity for the public to see that and ask for more time to review it. Right to a continuance. The hearing, or rather ORS 197-763 has a provision in it that says that at the first evidentiary hearing on any land use application, if there's a request before the hearing is concluded, it's automatic that the city has to grant a continuance or keep the record open to allow for written submittals. That'll be the case for you as city council members only for those quasi-judicial applications that come directly to you without the planning commission, because that you'll be the first hearing. If something went to the planning commission, however, and then it comes up to you, that opportunity has already been available to people. So you don't, it isn't an automatic right. But that's not to say that you don't have the right to continue hearings for more information or to allow for yourselves to, well, it might be midnight and you know you've got 15 more people speaking, you might want to continue to another date. You can do that with some limitations. You need to be concerned about a ticking time clock that we're going to talk about. But I wanted you to be aware there is a requirement for that automatic continuance in some cases. Scripts. The mayor will have a script that will have a lot of information from ORS 197-63. It'll say, for instance, the hearing is open tonight for the purpose of such and such. And by the way, you've got some great scripts. Tom gave these to me before. You've got both a legislative script and a quasi-judicial script. I didn't get a chance to ask Marty for hers, but your scripts comply with the statute. They have all the necessary language. And it will say, the mayor will say, this is what we're going to do. Here's what the hearings on this particular application. Here's how we're going to accept public testimony. Here's the limitations. And then the mayor is going to go through some procedural things, asking for the declarations of conflict of interest or bias. In some communities, they call on the city attorney to do it. And then the mayor will go through the process of opening the hearing and following this to the point of a closure of the public hearing, unless there's a continuance. So it's all prescribed and you have to follow that exactly. Well, most of it you have to follow exactly. There's some variance you can do, but there are some prescribed elements from ORS 197-63. If you don't follow that, then that can be a bad thing. You can end up having a decision remanded because you didn't follow due process. So the script should be easy for the mayor to follow, or if it has to be delegated to someone else, if the mayor has a conflict and not available. It should, the mayor might consider delegating some responsibilities on legal matters if you have a city attorney there. It must provide notice of the right to request a continuance, the one I just spoke of. But in your case, when it gets up to your level, that doesn't have to be there if it's not the first evidentiary hearing. And some cities provide the script to all council members because guess what? Usually there'll be something that gives you a hint on what to say for a motion. Because the staff might feel that this is, if the council agrees with everything we've said and there isn't any new challenges, this might be so straightforward that here's the motion. So you can really look good on your motion. Elements of the script. I just went through that to some extent. There's the opening statement, there's the hearing procedure, testimony order, how we're going to take public testimony, continuance, and some sample motions. What's an impartial tribunal? Parties have to have the right to a tribunal where each of the individuals is free of personal interest or bias. Members of the body may have situations, though, that challenge the ability of the hearing body to make an impartial decision. And we're going to talk about how you clear those up. They arrive through ex parte contacts, site visits. And I think a site visit is an ex parte contact, but some people argue about that. Conflict of interest and bias. Here's the procedural things to do. Ex parte contacts. They are when there's a contact by a party about a fact or an issue that's in front of you under circumstances that not all the parties to the proceeding are hearing the contact or getting the contact information. All three of these underlined elements have to be present for there to be an ex parte contact. So for instance, if somebody contacts you and it's not about the land use application, but you know that they might be coming to the hearing, but if they're talking to you about something entirely different and they never bring it up, that's not an ex parte contact. You might, however, be concerned if this person is somebody who is well known to be concerned about this application. They're either the applicant or a prime opponent. If the public sees you having a conversation with that person, you might want to declare that, oh, on last Friday, I ran into Joe at the supermarket. He's the applicant. I want you to know that we only talked about asparagus that day. It never came up about the land use, but I wanted it to be known that this did occur in case anyone was wondering. We didn't talk about the application. And then someone gets to challenge that. You might say, oh no, I heard you talk about such and such. And then you've got another issue to talk about. Contacts may be oral or in writing or emails, as I said. They should be discouraged in favor of the public hearing. So if you have the opportunity, once you know that an application has been filed or is likely to be filed, because the staff's keeping you apprised of, here's the applications that are working through the pipeline. Once you know that there's an application to be filed, that's when you need to start being concerned about contacts about potential land use application. If an ex parte contact occurs, the action that you have to take, disclose, make a record, and you can continue to be involved without influence. Here's what takes place. Put the matter on the record. It says at the next hearing, most cases it's the only hearing, but this is to let you know that you don't get to wait until the second hearing. You disclose when the mayor calls for ex parte contacts. And this will be before the hearing presentations start. Say, has anybody an ex parte contact to declare? And you may have a process that you go down the line of council members, or the mayor acknowledges the first person who raises their hand. And what you put on the record is, I had a contact by so-and-so on this date, or as approximate as you can be, about the following. This is what was discussed, and I want everybody to know about it. And ideally, you'll say, I am not influenced to the point that I can't make a full decision tonight.
Is ex parte only for voting members of the city council, or can this include the mayor and city staff as well?
It does not include the staff. It would include the mayor because the mayor's votes in the case of a tie vote. So when you make this disclosure, you do it before there's any testimony, if at all possible. It may be that you don't know that somebody is very opposed to this application until they appear and come up in front of the council and they start to speak, and all of a sudden you realize, wait a minute, that person contacted me 2 weeks ago, and it didn't dawn on me that what the property they were talking about was this property. Ask the mayor for the opportunity. By the way, before any more testimony, could I please make a disclosure? And it might be just that. I didn't realize until they came forward that they were interested, blah, blah, blah. But you need to make that disclosure, describe the substance of it. Be sure it's in the minutes. Just as I said the other day, make sure that your city recorder captures it. So be very clear. So it's in those minutes for your own protection. The mayor should provide the right to the public to comment on the statement or the communication. So there'll be a point that the mayor will say, does anyone wish to challenge the ex parte contact or the conflict or whatever of any of the members who spoke tonight? Now, I don't know what your local procedure is, but if somebody does challenge, then you're off to the races. What happens? Someone challenges. Sometimes the person who's been challenged says, for the sake of the group, I will recuse myself. And you can do that. Hopefully there's enough other people to make the decision. But you may challenge that and say, I just told you I'm not biased. I got the contact, but I can proceed. I am going to proceed. Then what do you do? In some communities within the council rules, there'll be a process defined where the council gets to decide whether or not the person participates, but mostly it's up to the individual. And you as individuals need to be thinking of the integrity of the process, transparency for the community, and your own personal protection in case you are making a mistake and get called up on charges. Failure to make a disclosure or an ex parte contact could result in a remand of a decision from the Land Use Board of Appeals. Site visits. That's when you go out to a site that's under review and you take a look at it. If you go after you've, well, before or after you've seen the staff report to gain information, you might see something that's not in the staff report. That information should be shared with everybody else. So the example of a site visit, you see that there's a piece of property that's going to be used for commercial use. It's in an area that there are several vacant pieces of land. You go, you follow the directions, you think you know where the address is, you look at the property, you see that there's a tree, there's no stream. You go back and you're looking at the staff report and it says there's a stream and all the trees have been removed. And you say, what's up with that? And you come to the hearing. Well, it's important that you be looking at the correct property. There've been cases where there's a lot of woodlands up on a hillside where it's really difficult to decide where the boundaries are. And you might form an opinion as to whether this is a developable piece of land or whether it's going to create problems of erosion for properties down below. And you might be looking at the wrong property. So it's important you put on the record what you saw so that either staff can correct you or community member can correct you, or everyone else just has the same information. Oh, I didn't notice that there was all those trees were removed, or there's one tree standing. Let's talk about that. Why isn't that shown on the plan? So they're legal, they're allowed if they are disclosed. So make the disclosure, state on the record the detail, who was talked to if you encounter someone, because that's often the case. Someone will come out and say, can I help you? And you might be talking to the property owner who you didn't know was the property owner. And they might tell you something that needs to be disclosed. Conflicts of interest. We talked about this the other day. Exact same definition that I gave you. There are potential conflicts where there may, through your participation, it may result, it could result in financial gain to you, your relative, all the things we talked about. And then there's the actual conflicts of interest. Potential, what should you do? You publicly announce this prior to participating in debate. Again, the mayor's got it on the script. Some communities have bias before conflict of interest. Regardless, you have to declare what your potential conflict is. And it might be, I live on Main Street. I'm 1,000 feet away from this property. My property is zoned such and such. That property is going to be used for this. I don't think it's going to impact the value of my property, but it could. So I just want to get that on the record. That may just be a potential conflict of interest. The other side, though, is you might say, I live on Main Street. I'm directly adjacent to the subject property. Subject property is going to do whatever. Whatever is going to take place on that property next door, if it's a change from the present use, it's probably going to have an impact on your property value, unless it's a very, very minor thing. That's an actual conflict of interest. If the conflict is not apparent until the hearing has begun, same thing. You might not have really realized exactly what the magnitude of the application is or where it is. So make sure you make the disclosure as soon as you can. Ask the mayor for the opportunity to make that disclosure if you missed it. When there's potential, you can take part in the hearing, but be concerned about the appearance. Because some people are going to think, even if it's 1,000 feet away from you, that's going to impact your property. I'm 1,000 feet away and I think it's going to impact me, so it's probably going to impact you, so they may challenge. If there's more than one hearing on a matter, best practice, you may make the announcement. If there's more than one hearing, you have to make the announcement every time. If there's a continuance at the beginning of that next hearing, the mayor's going to read the same script, make the same declaration. Might be different people out there. Actual, what do? Announce it prior to participation. Don't participate. Don't. You can't. You have to refrain not only from participating and making the decision, you can't participate in the debate. You can't ask questions. Get out of there. Have the declaration go into the meeting minutes and make the announcement at each meeting. So you're coming to the next meeting because there's other items on the agenda. You can come to the meeting. We want you to come to the meeting. Best practice tip, leave the room. I've seen situations where someone says, I'll just go to the back of the room. I won't bother anybody. But if the council's having discussions, somebody's going to glance back and see whether your head's going like this about a statement or like this, or you're gleefully going like this, acting. Someone's going to get the impression potentially that you're influencing the decision makers because they are people you know, they know you, they can read your body language. Best practice, get out of the room. Don't discuss it with anybody. So you get out of the room and then you're encountered in the parking lot. Somebody on the way in, what's going on? Well, the hearing's taking place. I just declared a conflict. Whoa, what's the application about? Well, you might be talking to somebody, you're now creating an ex parte contact and giving them some information that may or may not be a part of the decision. You can return for the next agenda item, so don't go far. Exception. This is what's called the rule of necessity. It's specific in ORS 244. See, that's not in ORS 197 land use, that's in ethics. That's in the ethics statute. It provides an exception if an official's vote is necessary for the local body to meet the minimum number of votes to take official action. So by somebody having a conflict of interest, if it's potential and they decide I'm not going to participate and that's their right, if they've created a quorum problem, they can get brought back. In fact, there could be a situation where 3 out of 5 council members have actual conflicts of interest and they all declare their actual, and I'm not going to participate. Next thing you know, you're down to 2 council members. You can't make a decision. If one option is you can flip it to the county, let the county board of commissioners make the decision. That's not very good. Most communities don't want board of county commissioners making local land use decisions. So the statute allows, in a limited basis, the opportunity for someone to be restored to the voting group. The process I've used in the past in a city, I think the city had 7 council members and 5 of them had a conflict. What you do is you listen to each one of the declarations and then you try to determine who has the least conflict, the least issue. And you can restore 1 or more people till you have just enough to conduct the meeting, to conduct the vote. But when you come back, if you're that individual who comes back, your participation is limited. All you can do is vote. You can't ask questions. You can't talk in deliberations. You just vote. You stoically sit there, let the other members do the heavy lifting, and then you vote. That's a rare exception. You cannot use this if the reason for your quorum problem is there's a couple people out of town or there's some other issue going on. You can only use it in a very rare exception. And I encourage you, never use it unless the city attorney guides you through the process. Personal bias. Bias is different from conflict of interest. This is when a member of the council cannot render a fair judgment because of a relationship or an acquaintance. It's not about financial, it's about acquaintance. So you might have a reason why you would favor somebody getting a land use approval or a denial, or you might favor somebody who is opposed to something. If you can't be fair and come into the decision and listen to everything that's brought before you and make a decision just on what's brought before you, not on your personal relationship, you cannot participate. Personal bias differs because there's no potential for financial gain, only relationship. What do? Make the same disclosure. State whether or not, in your opinion, it requires your disqualification. You're your own judge. But as I said, it's possible that a city could have a process where if the person is challenged, that the council may not want that person to participate because it's concerned about the decision. Simple bias doesn't require disqualification because we all know that, yes, you are in a community that you know a lot of people, but you can't let it change your fairness. Best practice, when there's a sufficient quorum, I recommend people think long and hard about not participating, but that's your own decision and your council's decision. Burden of proof. Any applicant for a land use application has the burden to prove that each and every one of the established development criteria have been met. They cannot choose to submit an incomplete application that doesn't address the criteria. It's their job. That's their job to provide you with the evidence. Now, the greater the change that's proposed, the greater the burden. So someone shouldn't submit an application that says, the criteria says must be consistent with the development standards, and here are the development standards, and have somebody check the box and say, I meet all the development standards. No, show us within your plan how you meet those standards. Where can we find it? Point to it. The burden is met by submitting a complete application with the evidence necessary to show compliance. Now, the practice that always gets my attention is when a city staff member makes a presentation, a great presentation. Here's the application, here's the recommendation of staff, blah, 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 goes through it all, answers a lot of questions from members of the City Council and Planning Commission. Now it's the applicant's turn. This is your opportunity. They come up and they say, I agree with everything the staff said. And then they start to move for their chair. Well, have they really met their burden of proof? Maybe, if their application was as complete as it was, but if the members of the Council of Planning Commission have questions of staff about the meaning of whether something in the application achieves compliance or not, they really should be directing those questions and get it from the applicant. But I see it over and over again. Burden of proof, continue. The applicant should respond to all issues raised by opponents. So again, the applicant sits down, now people get to come up and raise issues. The applicant has a chance for rebuttal, and that's where they should come back. And the applicant, when I say applicant, I'm using a collective way that it's the property owner or applicant, it's any of their experts. And sometimes they just have their lawyer or their engineer or their land use planner speak for them. That's fine, that's still the applicant. Applicants should not rely on staff presentations alone, and if an applicant or its experts provide new information at a hearing, the public should be given a chance to rebut it. And that may mean carry over the hearing for another date or to allow for written submissions. Appeal process. So here's what happens when the Planning Commission decision is appealed to the City Council. I told you that sometimes they're based on the record. That's not the case here. An appeal has to be filed by the applicant or someone with standing. Now, in one of your two communities, I noticed there's an interesting provision that says that the council can decide to waive that because a person has established by evidence that they were not able to participate at the earlier hearing. That was a unique one I hadn't seen before. I'm not sure how that process works. It may mean that there's a further delay of the hearings, but that's your own local choice and that's fine. But typically a decision to be appealed, someone has to be either the applicant or someone who participated in the local decision-making and has standing. Standing is established by participating, either in oral or in writing. Or in some communities, they will establish standing by you simply being required to receive a notice. So if it says notice, everyone has to be noticed within 500 feet. If you receive notice within 500 feet, in some communities, that alone is standing. You don't have to participate in the hearing. That's challenging, but again, that's a local body's decision. An appeal has to be filed within the established appeal period. I think yours is 12 days. I think it's 12 days, maybe 10. And it has to be in writing, stating the reasons for the appeal usually. In some cases where it's going to be a de novo hearing, all they have to do is say, I appeal the decision, because the council is going to hear it all again. But usually you have to state the reasons. Anyone who established standing has a right to participate in a city council appeal hearing. I think in your case, you let anybody participate, but in some communities, it's just those that appeared below. And again, that's why the local rules can allow a variance from that. If the appeal is on the record, the entire record is in front of council. That's not important to you. The record of the commission, well, you care about this anyway. These are all the documents that are going to be taken into consideration by the Planning Commission. You're going to have a similar set of materials that's going to be in front of the City Council as it decides the decision, either based, or rather, it's either in front of the council as the council, the first body to look at something, or on appeal. Council's appeal hearing, same thing. The mayor follows the script. The order is similar to that a planning commission uses for a decision. Typically, those who participated at the commission level are entitled to take part in the appeal hearing. You allow everybody. There's another staff report. Typically, the staff will identify what the reasons for appeal were that were raised and probably repeat their same recommendation. At the close of the public testimony after rebuttal, the council has the ability to deliberate. So what do you do when you deliberate? You close the public hearing. I'm not sure what your local process is, but what I've seen many times is the mayor will say, okay, who wants to open the discussion? Sometimes someone will open with a motion. I make a motion. Well, wait a minute. Shouldn't we allow the people to have some deliberation? So in some communities, there's a pecking order. There'll be the same individual always wants to be the first person speaking, or is the only person that's willing to step up and start the conversation. In some communities, it's required that everyone have an opportunity to speak before someone gets to speak a second time. But it's useful to have a conversation about, what did I see? What did I hear? What do I still have questions about? Because you can, if you want to reopen the hearing with permission of the mayor and their council, you may say, okay, there's enough confusion here. We shouldn't have closed the hearing, even though I tried to make sure that everybody got all their questions out. There's still some confusion. Let's reopen the hearing to talk about just this. Let's ask the staff or bring forward the applicant. If you bring forward the applicant, you need to let people rebut what the applicant said. Anyway, that's a long, involved process. But ideally, you get to the point that you're in deliberations, and after everyone's had a chance to make some statements, some communities, people will say, and that's why I'm leaning towards approval or denial. You might get a consensus building. And that might lead to somebody saying, well, based on what I've heard, I feel comfortable making my motion. And then you go through your parliamentary process. But again, that's up to you how you do it. Important thing, if the city wishes to continue a hearing because you need more information or as one's requested, you have to consult with the staff regarding the 120-day rule and how it applies to the application. 120 days is a statutory requirement. It was basically a compromise between the development community and local governments and citizens, where the state said any application, once it's deemed complete, the city has to have a process that you can get to the end of the review and decision making, including the local level of appeal, if one is available, within 120 days. That's a very aggressive timeline. And that's why staff will make sure that the application is complete and ask a lot of questions and make sure they have all the information they need, because once they deem it complete, the clock starts ticking. We'll talk a little more about that. A continuance I talked about is mandatory at the first hearing. If there's a request to continue a hearing to have more process or to leave the record open for additional written evidence, consider that clock. Issues with continuance. If you're going to have a continuance, at what point in the continuance hearing that's going to follow, where are you going to pick up? I've been to a lot of hearings where a planning commission or council says, we're going to continue this to a date certain. By the way, you have to establish when the hearing is going to be continued to. Otherwise, guess what? You have to go back and put out another notice. You don't want to do another notice. So you establish a date certain and a time, but it's also important to say, so here's where we're going to pick up. Either we've concluded the public hearing, we're not going to take any more testimony, we're just going to have deliberation by council, or we're going to continue the public hearing, we're going to pick up and talk more, and more public testimony is going to be given, or whatever it's going to be as specific as you can, because otherwise at that next hearing, there might be some misconceptions as to where you are. If the record is to be left open to accept additional information, here's what you can do. Instead of saying we're going to keep the hearing open and have more public testimony, you might be at a place that you've had enough public testimony, but there's just some issues about transportation or something else. So here's what you could do. You could say, we are going to give 7 days for anyone to say anything they want to, additional evidence they want to submit about that issue. You've got 7 days to submit. Once that and that could be the applicant too. Once that 7 days is over, you then provide all that information to everybody who's participated, and those people can rebut that information. And at the end of that 7 days, the applicant again gets the final word. They get to rebut the submittal about their information. So it could be a 21-day process. It's great if you have that time, if you need it, but most chances under the 120-day rule, most times there are not chances. Evidence. Evidence is what's in the record that's the basis of the council's decision. It's what people submit. Evidence is defined as facts, documents, and other information that demonstrate compliance or lack of compliance with the standards believed by the person who submits it. Evidence rules are not like evidence in a court of law. It's what someone believes should be considered, and it may not be totally factual, which puts you in a bind, of course. But administrative law standards apply. And administrative law says the evidence is the kind that a reasonable person would use in the conduct of their own affairs. It used to say business affairs in many cases, but what would you consider to be factual that you'd base a decision on? So that's your gauge. The council has some discretion, though, to determine whether evidence is submitted. Now, sometimes during a hearing, someone will submit something and someone else they'll say, I object to that. That information, that's a 1982 report. That shouldn't have any relevance. Well, are you going to waste your time at that part of the hearing to decide that you're going to toss that out and have an objection from somebody that they think that's valuable? Or why don't you just accept it and then talk about it later on as to whether or not it had any weight or any relevance? Make sure you look at it too, of course. During deliberations, the council can discuss and consider whether it's relevant, reliable, trustworthy. Substantial evidence is what you need to make your decision on. That means you're making a decision based on good, solid, hopefully a pretty good amount of evidence. But if the best evidence is, for instance, a new traffic analysis that was done last week at the same time of day as you're concerned about, and that is a one-page report with a stamp from a professional traffic engineer that you believe is competent, that evidence is over 20 people who have stood up and said, I stand by there and I watch all this traffic go by and they are always speeding. Which one is, do you have substantial evidence? Maybe. That's your discretion, your decision, and that could be enough. Evidence may be disputed. That's why we have land use hearings. So it's not uncontroverted. It doesn't have to be voluminous, but it would be great if it is. It could be voluminous on both sides, and you have to make a choice. There may be inconsistencies in the evidence. Your job is to pull out what you believe is most reliable, most factual, most pertinent. And you should determine whether the evidence that supports a decision when viewed in light of contrary evidence is sufficient. Same standard, that a reasonable person would look at this and say, I could reach that conclusion. Not that I would reach that conclusion, but I could reach that conclusion because that evidence is good. Substantial evidence is oftentimes an issue on appeal. On appeal, the standard that the reviewing body, in our case is LUBA, they won't disturb a decision that's based on substantial evidence if it's in the record. It's obvious you looked at it and you made some findings as to why you made the decision that you did based on that evidence. That's going to be the legal standard. When an item goes to LUBA, they're not going to retry the case. They're not going to have a hearing where they get testimony from the public or the applicant. They're going to be looking just at the record that you've created. And they're going to decide whether the decision you made is proper based on what your local regulations are, based on the statute, and based on what the facts were in front of you. The findings have to be sufficient to show that to somebody that's just looking at paper or listening to hearings. Admitting evidence, I talked about that a little bit. Best practice, accept the evidence conditionally and then have an opportunity to review it and make a decision whether to accept it and consider it. This is always a balancing act. You decide what you, as individuals, feel is important, and try to let your fellow council members know what your feelings are, because you may influence their decision. Raise it or waive it is an important component. Again, this balance between development and local regulation. The statutes say that in order for someone to raise something on appeal to LUBA, that issue has to be raised in the context of the city's land use process. Now, it could be raised at the planning commission or at the city council level if it comes up to city council on appeal. But the issue might be there's not enough information to support a conclusion that this criteria is met. And if in fact there isn't any information in there, that could be a reason for this decision to be sent back to the city to review the application again. But if somebody doesn't raise an issue and doesn't say this criteria should apply, they can't preserve the right to raise that until they get up to LUBA on appeal. And again, be concerned about that 10-page memo I mentioned to you. That if a lawyer submits a 10-page memo and on page 9, there's some issue about there's not enough information in the criteria, and there isn't, that person has preserved the right to raise that issue on appeal, even though you might not have noticed that it was in the record. To balance this ability for the city to avoid things being raised later in the process, the city has to comply with ORS 197-763 by following all these strict requirements on the notice, which means that you're giving notice to those people within X amount of feet, that you're telling them what the application is and what the criteria are. So this is your obligation. As long as you've, and that's why the notice is so important. If you've followed the notice to the T and you've got planning staff that do this, as long as that's in the record and you have an affidavit that you did the filing, you're going to be fine on review. The burdens on local government to properly issue the notice, but by complying with it, you avoid remands. Findings. Findings are the things that you adopt, the written statements that say that based on the information found in the record, these are the things that we found to be factual. This is the conclusion we've made. These are the things that we feel are relevant. And this is what we found to be the case. This criteria has been met or not met, and here's the reasons why. They explain the decision so that that independent review body, LUBA, has something to review and decide whether or not you did things properly. Because it's our obligations locally to follow the rules that we establish for ourselves. When it's approved, typically the applicant has given a majority of information, the staff's interpreted it and said it's good. Opponent testimony has been responded properly with other evidence, and it's approved. When something is denied, sometimes the staff will provide a recommendation of approval, and then it's denied by the city council. What you don't want to do is go against the staff recommendation and say, okay, we don't agree with the staff, we're going to deny it and not say why. Because typically what you're going to then do is say, staff, would you prepare some findings that tell us why we ruled against your recommendation? You need to put it into the record so the staff can take what you put in the record and put it into a statement that you can agree with. And then you have to adopt those findings. They're an outline of the evidence in the record that's been relied on. They should not, excuse me, they should not be mere conclusions that say it's approved because it met all the criteria. You need to say it's approved because it met this criteria this way, and this is what's in the evidence to show it. So it's drawn from the facts of the decision. Final order is the actual decision. It's issued that states what decision was made. It will tell what the appeal process is, and it will say what all the details are for someone who might want to appeal it. 120-day rule I mentioned. Problem with the 120-day rule, if you miss it, and you're going to be tracking this. If a decision goes beyond, is not made within 120 days, an applicant can proceed to circuit court and bring a judge their materials to say, my application met all the criteria at the local level. Would you, judge, please deem it complete and approve it for me? And if a judge sees as a staff recommendation of approval and all the criteria met, then again, it could be a tax judge, and I hate to pick on tax judges, I know they're great. But if the tax judge might say, yes, it looks good, I approve it. They approve it, and it may not have the conditions. They don't have to look at all the various conditions that you might have put on it, like participate in this study or add this to the approval. Okay, so I've known I've run late, but I wanted to mention too one thing that I thought of that's not part of this, and that is exactions. You need to be concerned about the conditions of approval that you put on a land use application. In the old days, pre-Senate Bill 100, someone came in for an application, they might be required to extend the water line to this far, build a additional lane of traffic, blah, 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 add all those things. That actually continued to happen after Senate Bill 100. Until some cases, the Nolan versus California Coastal Commission and the Dolan versus City of Tigard case, which is 1994 case, where it's been determined that if the city wants to put requirements on a developer to make improvements to infrastructure, and also extends to other things, those so-called exactions, things that are given up by the developer, they need to be directly proportional to the impact that is anticipated to be created by the new development. We can't put all the city's needs onto this developer because now we have this developer in front of us. So the city has to do what's called a rough proportionality analysis, where someone analyzes what is the impact? How much traffic is it going to generate? How much water? How is it going to affect our infrastructure? So that the applicant is being treated fairly and the community gets its fair share. Now, this also requires, I didn't introduce the concept of system development charges in detail, but you have systems development charges. In some communities, for someone to come forward and build a single family house, they might have to pay, let's say, $10,000 of systems development charges. Their contributions to the upgrading, future upgrading for capacity needs of the sewer plant, this water treatment plant, the road system, the park system. Some cities might charge $10,000. Others might charge $30,000 or $35,000, depending on what their infrastructure needs are and how they've defined it and what plan they have put together. To establish a systems development charge, you have to go through a process called a methodology analysis, where you look at all the present needs are of the community going out 20 years, let's say, for one of those services, let's say sewer, and what the needed capacity improvements are going to be based on what we anticipate the development to be. And we have to make sure we're only putting the burden on future developers that is attributable to the development, not what the existing need is that the community has that it hasn't been addressing for the last X amount of years. Those impacts, that necessity needs to be addressed by the city through its capital improvement plan and some other form of financing. But I wanted to make sure that I pointed that out to you because that's a critical thing. Land Use Board of Appeals, I'll go really quick, it takes 3 minutes. Land use decisions are appealed to that state board. They have to be appealed within 21 days. It's a simple filing. Somebody files a note saying, I have standing, here's my notice of intent to appeal. They submit a check for $400. That results in the city then needing to take some steps. And normally it's a challenge against the city's decision. The city then files the local record, which is a very complex thing to put together, and it has to be totally complete. And then there are filings that occur. I mentioned interveners only to show that it may be the person who challenged the decision and the city of the parties. Well, the applicant wants to get in as an intervener. It wants to be a participant. So it files to participate, and LUBA will grant an applicant the right to intervene every time. It may allow other people at other times. And then you go through a process of finalizing the record and then appeal, or rather briefs are filed. Once the record is filed, there's 21 days for a petition to file its brief, raising its issues, what's wrong with the local decision. Then the respondent, typically the city, will get to respond with its brief within 21 days, answering those questions. And sometimes there are respondent briefs. I'm sorry, sometimes there are reply briefs that raise other issues. And then LUBA conducts a hearing. Okay, the rules have changed. As of the beginning of this year, those hearings, just to show you how important the record is, the hearing takes place where the LUBA referees allow the following amount of time. The petitioner steps forward and they have 15 minutes to get their points across based on their brief and reserve from that 15 minutes some time for rebuttal. Then the respondent gets up and they have 15 minutes to present their case. And then and by the way, there's questions, just like any court proceeding. The whole thing's over in 30 minutes. And then LUBA is going to make a decision. Critical that your record be good. Appeal of a LUBA decision is to the Court of Appeals. LUBA can do one of the following things. They decide the process was done properly, so they deny the appeal. They decide that there's some procedural issue, there's not adequate findings, something wasn't addressed. They remand that, meaning they send it back to the local government for the local government to look at it again. Or they go against the city's approval and they reverse it. And when it's reversed, there's potential for attorney's fees. And we never want to get to attorney's fees because you don't want to pay somebody else's fees to challenge your decision. Any decision is appealed to the Court of Appeals. Sorry, I went over again, and I'm sorry I wasn't really attentive for questions. How about some questions? Yes, ma'am.
Bill, can you, since you just gave a lot of information, and I'm going to guess the counselors are going, oh my God, do I have to remember all this? You talk about how staff help walk counselors through this. They don't have to remember everything. This is just to make sure that people understand this process. And then there's a system, and then staff will help walk you through on a step-by-step. I guess I'm getting part of your presentation.
No, that's great, Mayor. Thank you. That helps me quite a bit. Yes. So the staff, again, are your experts. They're going to try to put into their staff report everything that they think you should know and point you in the direction of all the materials you should look at. Then at the hearing. Oh, but before the hearing, again, if you have questions, contact the staff. That's not an ex parte contact. Contacts with staff are never ex parte contacts. Contacts with the city attorney, never ex parte contacts. They're there to help you. When you're at the hearing, you're going to get a presentation by staff. They're going to walk through what they see to be the critical things that you should be aware of. Everybody uses PowerPoints today and helps you to see things visually, because we know some people learn from words, other people need to visually see it. Staff's there to be your resource. They want to answer your questions. And if they cannot answer all your questions, they may say, you know, we need to get another resource here, or I need more time. And that 120-day clock is not something that can't be moved. Sometimes there are reasons that the applicant is willing to grant an extension because they want to make sure that their application is solid when it gets approved. So they have to agree to an extension of the 120-day clock. But you might need another hearing, and you might say, well, in a subtle way, you're saying to the applicant, there's not enough here to approve this. But if we had another hearing and we got some more information, if you gave us another 30 or 45 days on the 120-day clock, we can do that. And the applicant will usually grant that to make it so. So staff's there to help you, and they'll guide you, and they'll prepare those conditions of approval and those findings. And typically the staff report will have draft conditions of approval and draft findings. Now, one last thing on a controversial item that comes before the city council. In most communities, it's just fine for the applicant to say, can I help you by preparing a draft of the findings? And that sometimes is really helpful for you because it might be more complete, there might be more legal analysis. They can only put in it what's in the record. But it could be helpful to you. Don't just deny it out of hand if it helps your staff. Other questions? Well, there isn't even a duck game today, so you've got time to stay.
Beavers at 7:30.
Okay, there we go. There we go.
Army Navy, I think it's over.
1 hour.
Yeah.
Oh, I forgot that one.
Yeah, it started early. Thank you, Bill.
Thank you, appreciate it. And on behalf of the COG, we're always there as a resource. I hope you take advantage of those materials that I gave to Karen. You can contact me. We're always happy to help with questions. And I hope this is valuable to you. And I'm sorry I go so fast and I never take a break. Hope you had a chance to take a break.
This is
Have a great
also
day.
Thank you.
available on YouTube, and I know people have already been watching from the last one, so it is available on YouTube, the whole thing. So I know some other people have been looking at it already, so thank you, Bill.
Great, glad it was helpful. Take care.
Thank you very much, Bill.
Yes, thank you, Bill. Thank you.
You're welcome.
And I would like City of Monmouth to know that I will be emailing those same documents from Bill over to their city recorder.
Great, thank you so much.